the 2022 webinar series of the Ecological Law and Governance Association. And what we do is we pick a theme important to us, our partners each month, usually the third Tuesday of each month, and focus on that and bring in our friends and experts. We've been doing it for about 4 years now, and all of the past recordings are on our website. And this month, is something for me that I have been wanting since the beginnings of the Ecological Law and Governance Association, and that is a serious conversation on the role of peace in ecological law and governance. So welcome. I am humbled by the theme, I'm humbled by these panelists, and I'm humbled by the participants. Just a few technicalities. We will be holding to 90 minutes firm, and that is to honor our recording and all those who watch afterwards. So please keep that in mind. We do hope to have question and answer at the end with any remaining time. If unavailable, we can work via email too. Just send any emails or questions to elga@elgaworld.org, and we'll make sure that the panelists receive them. Thank you. If for some reason the meeting drops and we all disappear, please use like 5 minutes to try to get back on. And if unable, then I will go ahead and we work with the panelists to record their papers, and then we'll put it all together and I'll share the link. So we'll still have this conversation no matter what. So thank you. And then for next month, February, just so that it's on your radar, we will be working alongside the New Zealand Center for Environmental Law and their 8th colloquium on frontiers and on frontiers and environmental law. So just head over to the website to check more information for February. So like I said, I have wanted this theme since the beginning of ELGA for how can we talk about ecological law and governance without talking about peace and the systems that nurture it and the systems that prevent it. And when I talk about systems, I talk about the people, the actors, the institutions, the economic systems, the governance systems. It's all connected. We are co-hosted today by the World Future Council, which couldn't be more appropriate, with the support of the Ethics Specialist Group of the IUCN World Commission on Environmental Law, the UN Harmony with Nature Program. But for the World Future Council in particular, and Alyn may actually speak to this, but one of its counselors was Justice Christopher Viramontree, who did the dissent on the legality of the use of nuclear weapons. And Alyn was actually part of that case as well. So he can certainly speak to it more than a scholar can, more intimately than a scholar can, which appeals to everyone at the end. It appeals to all humanity that we remember our humanity and forget the rest. And that is foundational to why we're here. And then, of course, there's his separate opinion on sustainable development, which speaks to future generations, the need to go to other cultures, Earth trusteeship, all of these principles we cannot separate. So that's why we're here today. Also, perfect timing. This week, yesterday, the United States honored Dr. Martin Luther King Day with our national holiday. It recognizes his life, his work, his continued struggles. I actually told some students today, I feel like it's more of a memorial holiday than necessarily a celebration. And his entire being was peace only through nonviolence. Through nonviolence, and in order to attain it, we must address the 3 evils, which are racism, poverty, and militarism, the military might, military funding. And then of course today, Reverend Barber and others add ecological destruction. So after all, we cannot talk about peace with Earth without talking about peace with one another. So to that, let's get to our program for the day. Myself, I am a founding member of the Ecological and Governance Association, Executive Director of the Center for Environmental Ethics and Law out of the US, Chair of the Ethics Specialist Group for IUCN WCEL, and also Professor. Okay, now for our first speaker, Alyn. Alyn Ware is coordinator for Peace and Disarmament Program with the World Future Council. He's a peace and disarmament educator and advocate from New Zealand, now living in the Czech Republic. He's co-founder and CEO of Parliamentarians for Nuclear Non-proliferation and Disarmament, director of the Peace and Disarmament Program for the WFC, as I just said, the international representative for New Zealand Lawyers for Peace, and director of the Basel Peace Office. In his former position as executive director of Lawyers Committee on Nuclear Policy, Alyn was one of the leaders of the advisory opinion case against nuclear weapons before the ICJ. And today, Alyn will be talking on nuclear weapons and law for the future, the application of principles protecting future generations in international tribunals. And at 15 minutes, I'll be giving you a warning to wrap up in the next 3 minutes, okay? All right, welcome, Alyn.
Thank you very much, Kathryn. Thank you for the invitation to participate in this event. It's a great honor. As you mentioned, I'm with the World Future Council, which is based in Hamburg, but has got councillors around the world. And the object of the World Future Council is to highlight best practice, best policies for protecting future generations. So that's the range of different issues that are facing us in terms of ensuring a sustainable world, like human rights issues, finance issues, climate, energy, peace, disarmament, the range of issues. And many of the members of the World Future Council have been engaged in the development of some of these policies. That's why they're sort of chosen to be on the council. And as you mentioned, I came to be invited to be on the council because I was one of the leaders of the case in the International Court of Justice in 95-96 on the legality of the threat or use of nuclear weapons. And you mentioned Judge Gwiazdon. He was one of the judges at that time and gave an incredible separate opinion, which went into a lot more depth and detail, particularly on some of the conceptual aspects of environmental law and law protecting future generations that back in 95-96 weren't fully manifest to be able to be determinate in the result of that. And since then, they've developed a lot. Also, as you mentioned, I'm with the New Zealand Lawyers Group, which we use the Indigenous name, Aotearoa, for New Zealand, which is also an official name. We have both names are official, so it's Aotearoa Lawyers for Peace. And I'm involved in a number of nuclear disarmed organisations. I moved over to sort of the Northern Hemisphere, I guess you'd say, from Aotearoa, New Zealand, after we banned nuclear weapons in our country. But we realised, no, even though we're islands, in the interconnected world, no island is an island by itself. These issues, whether it's nuclear weapons, whether it's war, whether it's climate issues, whether it's impact on the oceans, many of these issues, most of the critical issues of today are trans-border in impact and transgenerational in impact. And so that's why engaging in the international bodies and in international networks is so important. And many of them are based in the Northern Hemisphere, whether it's United Nations in New York, Geneva, Vienna, the International Court of Justice in The Hague, plus other tribunals. There are many others. I'm just going to look at a couple of them because we've only got a certain amount of time. And I'm focusing not just on nuclear weapons, but also I'm going to touch on climate change. But I'm going to start on the nuclear weapons issue because that's where I have most of the experience and background. So I'm going to look at, in a sense, giving a picture that the principles of international law protecting future generations, and I link those with peace as well, because for me, a peaceful world is one which isn't just static, it's one that's ensuring peace is sustainable for future generations. And the key reason I got involved in peace and disarmament work was in order to ensure that we have a safe and sustainable world for our future generations. But I'm going to focus a lot on the nuclear weapons issue because we have some case examples, we have law that's clarified on that, and it also points to the broader aspect of peace because the whole aspect of nuclear weapons, they're a political weapon. They're not really a military weapon. They're not being used in current battlefields. They're produced by countries as a political tool, and it's part of the function of not being able to resolve conflicts in peaceful ways that they're resorting to the threat or use of force, and the ultimate threat of force is nuclear weapons. So the nuclear weapons issue is tied up with the whole peace dynamic. and I'll focus a little bit on that. So I'll look at the 1974 nuclear test case, the 1996 advisory opinion, the 2016 nuclear disarmament case, and then one which is a People's Court, the 2017 People's International Tribunal on Nuclear Weapons, and then relate that to a current campaign to take the issue of climate change to the International Court of Justice. So going back to the 1974 nuclear test case, this was actually what stimulated me to change my career from being a teacher to get involved in international law and politics, because I come from Aotearoa, New Zealand. Our countries in the Pacific were being impacted by the nuclear tests of the big powers. They were testing their most destructive nuclear weapons in our part of the world. So the UK, France, the US were testing them in that area. And the impact of those was horrific. The radiation that was being distributed through the islands was causing horrific cases of thyroid cancer, leukemia, brain cancer, deformed babies, stillbirths. It's horrible, the health impact. And this is nuclear tests. This is when you can decide when or not you're going to test it away from population. Imagine what would happen in a nuclear war where you don't have that. It would be so much worse. So to me, I realized I can't just be a teacher, like preparing children for life if I'm not also engaged in ensuring that there is life for them and a safe and sustainable life. So I got involved in nuclear disarmament and in helping make our country nuclear free. But I could see that, we may be able to influence our country, but how do we influence the big countries that have the nuclear weapons? France, the United States, Russia. And that's where I saw this case, which came before my time, 1974, and how effective it actually was. This was Australia and New Zealand took France to the International Court of Justice over the nuclear testing because of the environmental and health impacts of the radiation, which was transborder. So they could use transborder law at that time. But what New Zealand and Australia did is they also brought into their cases, and this is back in 1974, principles about protection of the future. So you see this in these two quotes from submissions. In the New Zealand, it talks more about the idea of a future of international security. So again, this links the nuclear issue with a peace, and that peace has to be sustainable. So that has to last into the future. So already we're getting a trans-temporal aspect of responsibility to protect from things like nuclear testing and war. And then the Australian submission talked about the genetic mutations which are transmitted to offspring of exposed persons impacting future generations. So already we had some work happening back then on this protecting future generations. The case itself was interesting because it had the political impact in that France stopped the atmospheric tests, but because they stopped the tests, the judges discontinued the case. So we didn't actually get a final outcome from the case. But we did with the next case, which was one I was more involved in, and this is the advisory opinion on the legality of the threat or use of nuclear weapons. Now, advisory opinion is a little misleading because the International Court of Justice can consider different cases. And an advisory opinion is not just a matter of giving an opinion. It actually is a real case in the court. So the terminology is a little strange, but they use that term to distinguish it from a contentious case. And what the difference is a contentious case is basically where one country or two countries take another country to the International Court of Justice based on a charged violation of international law that relates to those two or three countries. That's why it's called contentious between specific states. An advisory opinion is just as much a real case by the International Court of Justice. It's just as much a case where the judges will examine the situation, apply the law, and come out with a decision. But in an advisory opinion, it's not specifically to do with one state action and one other state being harmed by that action. It's about a question of international law. And in this case, this was the civil society, basically, in New Zealand decided to take this case to the International Court of Justice. And it stemmed from a conflict between New Zealand and the United States, where we banned nuclear weapons The United States didn't like that because we were part of an alliance, a military alliance, and they said, well, you can't pick and choose which weapons you're going to be defended upon with if you're part of this alliance. And we said, well, yes, we can. We believe nuclear weapons are illegal. And so a wonderful professor in the United States, Professor Richard Falk, basically advised us, said, if you've got a dispute on a legal matter, the International Court of Justice is the place to take it. And we go, yeah, but how do we take the United States to the court? They withdrew their acceptance of jurisdiction for contentious cases when they lost the case with Nicaragua. And he said, but there's an advisory opinion approach. And we said, we don't want an advisory opinion. He said, no, it's a real case. So we were convinced. And to get there, though, our country couldn't take it as an advisory opinion. You have to get that case taken by a body of the United Nations that has authority to take a case to the court. So we went to the World Health Organization and the UN General Assembly and managed to move both of them to take the case to the court. And then we got a whole lot of countries to participate in the case. Here you see the judges of the court deliberating on this issue. And I say we basically won the case. Because the final decision from the court was that the threat or use of nuclear weapons would be incompatible and would violate the laws applicable, generally violate the laws applicable to warfare. And this includes two main bodies of law of peace and security and international humanitarian law. They were the two bodies of law that the court applied. And the court then said, and there's an obligation to negotiate for complete nuclear disarmament. So it was a pretty good outcome for that court. Within there, as I mentioned, the main body of law was not environmental law. The main body that they applied, they didn't really apply human rights law. They applied primarily law of peace and security and international humanitarian law, laws applicable and written, basically, and codified to deal with conflict. But there was quite a lot on environmental law and principles inside that. And here are a couple of examples. Within the deliberations of the court, they addressed the Protocol 1 of the Geneva Conventions, 1977, which prohibits the employment of methods or means of warfare which are intended or may be expected to cause widespread, long-term and severe damage to the natural environment. So it's actually, it is in law applicable in wartime consideration of the environment, and also the prohibition of military or other hostile uses of environmental modification techniques. So it was in there. But more than that, and this is where Judge Gwiazdon, I think, played a key role, is looking at the broader aspect of law, which is customary law. And when you're bringing customary law, you're talking not just about the specific treaties, but also about the general practice and the acceptance of principles, about learned opinions. There's a much broader body of law, and Judge Gwiazdon brought that into this case, as he did with many cases when he was a judge on the International Court of Justice. And he influenced the court to come out with statements like this, that not only on the impact of nuclear weapons on the environment, on ecosystems, causing genetic effects, and to future generations, but also, and this is, I think, one of the best quotes from the court, the destructive power of nuclear weapons cannot be contained in either space or time. So here we have both the transgenerational and transborder application of this. So this was very important seeds, I guess, to further work that's been done on this type of law. This was advanced a little bit further in the Marshall Islands case against the 9 nuclear armed states, which was in 2016, where the Marshall Islands brought in additional evidence with regards to transborder and transgenerational impact of nuclear weapons. So here, for example, in their testimony, they quoted from the final outcome document of the Vienna Conference on Humanitarian Impact of Nuclear Weapons, with regards to the regional and global consequences of nuclear weapons, which went even beyond environment and human health, but also socioeconomic development, social order, etc. So there was more put in. Unfortunately, with this, the court turned down the case on jurisdiction grounds, and so we didn't actually get a final outcome of that one. So the one other one I'll look at, And this is not a formal government court, but this was a people's tribunal. The people's tribunals are very important because they give an opportunity to be able to bring forward more additional research, principles that might not have yet been tested, apply some of the principles of law to fact sets, prepare for possible court cases. So the tribunals, I think, if they're taken well and done seriously, which this one was, this was a tribunal that was done in 2017 at the University of Sydney and included a prosecution team and a defence team. And this one was actually a criminal tribunal. So it was like putting on the leaders of the nuclear armed states for their criminal responsibility for the violations of law involved in the planning and preparation for the threat or use of nuclear weapons. And the judges convicted. I say it's a people's court, so it's not a formal one, but they saw that the evidence was sufficient, and they used a lot of evidence which was presented by Professor Emily Gwiazdon, who's speaking later today, on the rights of future generations, and again the additional evidence. And this was interesting because it looked at a whole wide range of aspects of protection of the rights of future generations, including, for example, the future generations of combatants. And combatants are legitimate targets in war, but not their offspring. So if you're having a look at international humanitarian law with a trans-temporal perspective, which is what Professor Gwiazdon brought in, you have to consider not just the impact of warfare on the combatants themselves, but their offspring, and so on. So there's, I think, some very interesting principles in there. And this gives, I think, a lot of basis for applying these principles, particularly protection of future generations, also to the climate change issue. Now, there have already been a number of national cases. I'm not going to go through those. You can have other experts. A number of the national cases which have looked at the rights of future generations have been explored in a webinar series, which the Normandy Chair for Peace and World Youth for Climate Change have been organising, on the types of law which could be applied in an International Court of Justice case on climate change. And if you're interested in that, then I would recommend joining one of the future webinars that's been organised, and I'll put the contact details on there. So what's happening here is that based on the success of the advisory opinion on the illegality of the threat or use of nuclear weapons, a couple of initiatives popped up, one with Normandy Chair for Peace and one with students from the Pacific, and then they've sort of come together and cooperating to take an advisory opinion to the International Court of Justice on the issue of climate change and bringing in the responsibility to protect future generations and what are the responsibilities that come out of that. And with this broader range of law that could be applied, one could expect a decision from the court that could have considerable impact on putting a lot, increasing incredibly both the legal and political pressure and the framework for better action from governments to move beyond what's happening at the moment, which is sort of like a political negotiating process that is lowest common denominator in trying to move forward. You basically move forward on the basis of getting agreement from all the key countries. Bringing in a legal focus can help push us much faster towards really ensuring that we keep below 1.5 degrees and that we can ensure that we have protection of the planet for future generations. So I'm just sort of touched a little bit. I'm sure that Professor Gwiazdon will go into more detail on some of the legal principles because that's her expertise field. But my field is like putting that legal expertise into some political process. And through the UN system, and particularly looking at the International Court of Justice. So I'm assisting as an advisor to help World Youth for Climate Justice and Normandy Chair for Peace sort of get a political strategy to get the case to court and then win the case. And already Vanuatu has announced that they will be starting the process of getting a UN General Assembly resolution. So thank you very much. That's a little bit more sort of political framing of this with some touching on legal principles, but I think it puts in context a little bit more of what some of the other speakers might say. Thank you.
discussion. And I would really love to see an advisory opinion move forward on climate change in future generations with the ICJ. I think it would also raise the legitimacy and power of the court in international environmental law development. It's one of those topics they need to address, for their own legitimacy. So I'd love to see that move forward. Thank you. Next, we will move to Professor Don Oh. He's a professor at the Aju University School of Law in South Korea. He is also on the editorial committee of Democratic Legal Studies. And how I met him, he is co-representative of the People for Earth Forum in South Korea. So welcome. It is wonderful to have you.
Nice to meet you. Hello, I'm Dong Seok-woo. I'm very grateful for giving me the opportunity to present. I'll skip the introduction and move on to the main topic right away. I'm not good at English, so I'll read the manuscript I prepared. I remember keeping Earth Peace is one of the main themes of my childhood animated films. The main subject of invasion was an alien. In the Netflix movie Don't Look Up, communists outside the Earth appear as the cause of the destruction of the Earth. But as history has shown, the main factor behind the collapse of any system was inside. The threat of Earth's peace is also within the Earth. The existing concept of national security distinguished between enemy and comrade, the outside and the inside, and always assumes external enemies. The concept of international peace as a state of war inhibition is a problem with the Earth from the Earth's point of view. The Earth's climate crisis is not caused by external enemies. We know relatively clearly where the cause of the problem is inside the Earth and where it comes from, but it's not easy to clearly identify the enemy. The concept of human security of life security turns human being and life over two security concepts. For example, dualism that distinguishes the outside from the inside. The abstraction of human and life concepts does not help solve the problem. It is the responsibility of all humans, but not all humans are equally responsible. The victims are all humans, but the extent of the damage is not the same. Responsibility and damage are not proportional, and in some cases are inversely proportional. Korea, where I live, is currently largely responsible, but the damage is relatively small. As a person living on Earth, the responsibility of the society and the state in which I live feels great. It is not just a matter of guilt, but a matter of responsibility that must be done to solve the Earth's ecological crisis. The key messages of the IPCC Working Group report provides a high-level summary of the understanding of the current state of the climate. Today, the responsibility of the countries that have accumulated wealth and the responsibility of the countries to grow in short period of time, for example, South Korea. The gap between the time to accelerate the climate crisis and the time to respond to it is remarkable. Some predict that it has exceeded the tipping point. In Korea, the resolution of the climate crisis is linked to economic growth and is not out of its stagnated state. Policy and legal responses are taking place leisurely as if we have a lot of time left. So I came to think about how to share the norms and principles of other countries that are ahead of ecological legal action. It was also a matter of incorporating Earth's jurisprudence, which had just begun to be learned in the Korean law system. Article 3 of the Korean Constitution is the territory of the Republic of Korea shall consist of the Korean Peninsula and its adjacent islands. It is important that the territory is part of the Earth here. I think territorial safety is the safety of people and ecosystem living in the territory, and it means the human life must be lived on the premise of preserving the global ecosystem. And Article 5, the first paragraph is, the Republic of Korea shall endeavor to maintain international peace and shall denounce all aggressive rules. Now, peace is peace with other species and peace that everything must be safe in the Earth's ecosystem. The aggressive rules that must now be denied is an attack on the Earth's ecosystem caused by humans attacking their existence itself toward non-human beings. It is also an attack that harms ourselves after all. Mary Christina Wood evaluates that US environmental law has failed, though the administration gained the authority and funding to carry out the laws. Agency became captured by political powerful interests, and its dysfunction now operates on dangerous system global level. Although there may be a large variation from country to country, it is probably not very different in most countries in terms of the Earth's ecological preservation. Even if a country has good ecological legislation, it has no choice but to have territorial limitations in the current international legal system. It is not easy to regulate one's own companies outside the territory of a country. The ecological peace of the Earth is largely confined to the limits of national states and capitalist corporate activities. It is not easy to overcome its limitations in realistic dynamics. There is also a limit to controlling a country's desire for economic growth and a rich life at the level of international law. Currently, the international legal system has the nature of intersection under the agreement of each national state according to sovereignty. So the international effect is very limited, especially if the powers do not agree. The ecological peace of the Earth is to prevent the biocide and geocide that destroyed the Earth's life system. It is the peace of the Earth as a harmony with nature. Humans do not invade the habitats of non-human beings. I'll skip this part. Klaus Wasserman points to the main issue of global governance as to how to express the protection of the Earth and ecosystem through politics, law, and governance. He proposes an Earth trust system and argues that international law and the United Nations are ready to develop a trusted governance organization. As an example, models such as the United Nations Trusteeship Board, the World Health Organization, and the World Trade Organization are presented. It can be easily reborn as an environmental trust committee. I think Wasserman's argument is very meaningful. Nevertheless, it is questionable whether the logic of power is sufficient as a solution to the global ecological problem through international law or the United Nations. This is because the main parties threatening the Earth's ecology are at the center of eliminating the threat. The concern of how to overcome the reality that a small number of powers dominated international organizations requires a methodology that can surpass the past. So I argue the constitution interpretation, for example, South Korea. Article 122 of the Korean constitution recognizes the land of the nation is the basis for the production and life of all citizens. This regulation presupposes that Korea's territory is part of the earth. So the earth is the basis of life on the earth. On earth, each country's territory is not subject to exclusive control of sovereignty, but the home of beings who exist and live on it. No one has the right to cause the extinction of other beings or destroy the earth, a common base itself, even though there is a struggle for survival. The safety to all beings on Earth is dangerous. Paradoxically, we included in humans are both victims and perpetrators. It is not a matter of individual morals, but a matter of social and the Earth norms. Therefore, I argue that Article 122 of the Korean Constitution should be interpreted, including the phrase in parentheses. In harmony with nature on Earth, all citizens plus being on Earth. And establishing the best interest principles of the Earth and of the ecological law governance to the highest level possible. These principles are derived from the principles of guaranteeing children's human rights and health rights in international human rights law. Projects are needed to share ecological law provisions for the Earth peace in countries around the world. Those ecological law provisions are not the state's sovereignty monopoly norm, but the Earth's shared norm. It is an approach based on a legal system that forms a combination of the best ecological law principles, and it's necessary to share ecological science and technology, not economic aid or development. For example, Denmark's Climax 2, Germany Constitution, protection of natural resources. 3, example 3, Constitution of the Republic of Ecuador, the rights of nature. 4, German Constitution, right to register. The first example is German Constitution's provisions of the right to resistance. There is no intention of humans, but I think there will be a certain reaction in situations where living things such as animals and plants or non-living beings can disrupt or threaten the Earth's ecosystem due to human influence, especially in situations where it is difficult to survive. Recognizing rights to nature is bringing nature into the human legal system. That's meaningful, but its limitations are also clear. Perhaps it is more appropriate understanding that all beings have the natural right to resist breaking the Earth's peace state. First, we need to know what kind of behavior humans have brought about resistance from nature. Second, we have to make them understand how the resistance of nature is taking place. So it is necessary to communicate with nature by mobilizing all the abilities that humans have developed by resonating with nature so far. It will be a task for all human disciplines to think about together. First, we need to deal with how humans will reconcile and harmonize with nature again at the Earth level. Finally, it will nevertheless be a process of humbly realizing that the Earth ecosystem has limitations in human abilities that cannot be completely resolved by human will. The way to build this ecological law governance is to form and expand the common zone of ecological law beyond the territory of each country. I'll wrap up what I'm saying now. Now, it is necessary to promote the revision of the written law in an ecological direction, recognize advanced ecological norms and principles of other countries as the ecological law of the Earth, and accept them as norms and people living on Earth should respect. It is also a process of reaffirming that the rights of all beings are sources of law that must be shared and used on Earth. I think the governance of ecological laws that make it so is the foundation of Earth law governance created by people on Earth who desperately want peace on Earth. Thank you for listening.
An evolution of constitutional law approach to this, the foundations of our nation state. And you go from Earth trusteeship, which I know Professor Bosselman is continuing to build and expand on, with this right of resistance. I have never heard that in this discourse, and I love it. And it's something that we can all understand, you know. So I look forward to working with you more on this. Thank you so much. Okay, so next we will turn to Juan Carlos. I apologize if I mispronounced your name, Juan Carlos. Sansborgo, please correct me. I probably did it wrong.
Sounds perfect. No problem about it.
I apologize. The Dean of the UN University for Peace. Juan Carlos is Dean of the University, which is created by UN mandate. He's a professor of international law. He's also a tenure professor for the Institute of Public Law at the Universidad Central de Venezuela. He's a Fulbright visiting scholar with Washington College of Law, American University here in DC, where I'm located. Adjunct professor at the Universidad Alfonso in Madrid, Oregon State University. The list goes on, and the world, the academic, scholarly, student world is lucky to have you. And we are lucky to have you here today. He will be speaking on SDGs as a point of departure. Welcome.
Thank you very much, Kathryn. It's a pleasure to share with you. I would like to use to share my screen too, to share a little bit something that let's see if we can do it. Let's see if that will work. Yes, it's working. Perfect. Let me move this to the other side and you know, let me do it this correct because that okay. Well, thank you very much for the opportunity to share with you with your group and with this distinguished group of panelists some ideas about the peace and ecological law and governance. I think that, you know, what Alyn Ware says before about the nuclear tests and what Professor Donghae has says, you know, really open the minds. And I would like to share some perhaps from my point of view, practical ideas or practical approaches of how we should move forward on the idea of peace and ecological law and governance. And my point of departure is Agenda 2030. I mean, the Agenda 2030 is many things. For sure, it was an important success when the agenda was approved some years ago, and it was the center of the whole debate around the world, around the whole diplomatic issues, and for me, it's still extremely important because even though it was approved in something that looks like last century, because, you know, with the pandemic, everything has changed a lot. And some of the goals that the international community decide when the Agenda 2030 was approved, as you know, go back in a terrible way. Just to share, for example, that Secretary General Guterres shared some month ago that for the first time in the 21st century, the extreme poverty has raised. I mean, we have, since the 21st century start, we have been steadily reducing the extreme poverty around the world. But as a result of the change of priorities on the governments, to reduce the extreme priorities or poverty, has changed focus because we have to work on the pandemic. So I turned back on the idea of the General Assembly. The Agenda 2030 was approved by the General Assembly, and the General Assembly remains as the most important body for the world governance. And even though we had many attempts to reform the whole UN system and the idea that, you know, we should have a more democratic and balanced governance around the world, basically that the Security Council should be in a more balanced way, and the idea to create another council, that is the Human Rights Council in Geneva, the General Assembly is the main forum for discussions around the world. But this is not just the forum to discuss. It's not just a place where ambassadors meet to exchange views around the current political affairs. It's the most important body for the governance at the multilateral level. And this is very, very important because we need to realize what is the role of each of these ambassadors sitting at that and these tables. Because when we think about these people sitting there, they are not just, you know, the representatives of the government. They represent the country as such, and they are all civil servants. And as a result, their vote represents something from the state. And of course, we can go one by one, we can discuss many things, but we cannot deny the political importance and the legal binding of the and the effects of the vote of one of these ambassadors. So when oops, so basically my point of discussion is the Agenda 2030 is just a political agenda or a legally binding document, okay? And I think this is extremely important to draw a work plan for the international community, but also for the civil societies around the world. If you ask many governments around the world, and you ask, you know, what is the Agenda 2030? They will reply you straightforward, it's a political agenda. It's a political agenda because it was approved by the General Assembly, and the General Assembly basically what they can produce are recommendations. And you say, yes, I mean, you know, if you apply the text of the UN Charter, is what it says, you know, the General Assembly just approved recommendations. However, we all know that in the last 70 years, the way that we create international law has changed a lot, and especially on the top and the importance of the customary norms. That's why I believe that we need to go back and check a little bit what are the sources of international law, following what the Article 38 of the Statute of International Court of Justice says. And they say, you know, we have two main sources, that is the treaty and the customary norms. We all remember that, you know, we have the rest, that is, you know, the general principles of law, the jurisprudence of the doctrine, but we know that the focus of the international community is treaties and customs. However, governments are normally against they consider customary norms binding, because customary norms are something that for the government is very difficult to control, because, you know, the emergence of new norms is something that is very difficult for the government to control in comparison with treaties. Treaties are pretty simple. It's a piece of paper that they negotiate between the parties. They have a pen, they sign, they send it to the parliament, to the Congress, or whatever legislative body, and they approve. But in the case of the customary norm, it's something that basically is made of the constant repetition of certain actions, okay? And when we review the definition of customary norm made by the Statute of International Court of Justice, they refer a practice considered as law. So basically, when we visit the Agenda 2030, none of the 17 goals that they are part of the Agenda 30 were created on a vacuum. They all are part of the evolution of the most important concerns of the international community that were already part of certain degrees of legally agreements, okay? If we visit each one of them, you know, from no poverty to climate action, from life below water to gender equality, we will find that all these goals are built over consensus on different elements of international law. So in the article that I share with you, that Kathryn asked us to share it before the talk, is you know, had been publishing on this line, that we need to recognize on the Agenda 30 that it's not just a political agenda, that Agenda 2030 basically is part of the effort of codification of international law, is part of the process of when the United Nations take all the previous agreements and at the international arena and give them certain legal right, certain legal value. You know, I can spend, and probably Alyn and I, we can start to discuss about all these elements of law and then how we apply customary normative, but I don't want to go in that line because I think it's extremely technical and I think it will be a waste of our time. Basically, what I want to transmit is for civil society, for people who wants to work on the idea to produce change on the society, they need to see these 17 goals as commitment of their governments, that they are legally binding by the governments, because otherwise, what is the purpose of the UN? If you have an ambassador sitting on a chair with the name of your country on the top, and he's accepting this type of obligation, and they are just political recommendations, I think it's a waste of time and waste of money and a waste of resources. These 17 goals represent the evolution of the international law, the evolution of many topics that, you know, is a consensus that, depending of the topic, they are more or less binding for the government. But clearly they represent a plan, they represent a blueprint for any civil society organization, any institution who would like to work on any of the 17 topics. I mean, from, you know, decent work and economic growth, reducing inequality, responsible consumption and production. You will have there what the international community wants to achieve, what are the way that we're going to measure these achievements, and you will find what the international community agreed that is the best way to work with the government from the civil society perspective, but also from the point of view of the domestic law and the domestic governments, and on top of that, how you work at the international level, at the United Nations level. So every time that I have the opportunity, and thank you again, Kathryn, for this wonderful invitation, I show this to the people. Look, this is not just a lovely idea, a nice poster that we see to follow. And the only way that the governments are going to do it is because civil societies in democratic countries, civil societies around the world have to push the government to get what they agree some years ago that should be these sustainable development goals. This is Kathryn and my colleague, what I want to share. I want to stay very close to the time because I really would like to have an open space to exchange. Thank you very much. Wonderful. My gratitude for this space, and Kathryn, I give you back the microphone. Thank you.
Great, thank you so much, Juan Carlos. And thank you for the call to revisit the SDGs, because I think it's something that everyone that works in this field agrees with. They were written and drafted and adopted with the best of intentions, yet they're failing. And why are they failing that? Is it the institutions that they've placed within? Is it the development approach? Or is it, as you said, they're not seen as binding when they could be? So we need to empower civil society to demand governments to be held to account for the commitments that they make. And that is something that is, you know, common sense for international law. So, okay, thank you so much, Juan Carlos. Okay, and next we will turn to Amélie Gaillard, who I had the pleasure of meeting last September for the first time, and I'm working more and more closely with, and I'm very excited for our future. She is an associate professor in private law at the Sciences Po Rennes and co-head of the risk division of the MRSH Caen, France. She defended in 2008 a thesis entitled Future Generations in Private Law Towards a Law for Future Generations. And this was in 2008. So she was at the front of this fight for future generations. For this book, she's been awarded a prize by the French Academy of Political and Moral Sciences in 2010. Her work highlights the emergence of a new temporal paradigm, which renews the legal framework, but also initiates a new legal logic. She strives for a revitalized juridical humanism, which respects both humankind through time and space and all the living and supporting conditions for life. She writes in philosophy, legal theory, international human rights law, environmental law, constitutional law, everything. She's the general coordinator for the Normandy Chair for Peace, and it's an honor to have you here. Today, she'll be speaking on towards a transgenerational approach of human rights and, importantly, duties. Welcome.
Thank you so much, Kathryn. Hello to everybody. I'm very pleased to have this opportunity to see you again, to see my friends Alyn Ware, and to meet you, dear colleagues who are sharing the same humanism, open to peace and to the protection of future. So yes, indeed, I would like to share with you this transgenerational approach of human rights and duties, which is at the core of all my research. And here, maybe I have to put out the video. Is it correct, Kathryn? Do you see? So in order to introduce this topic, I would like to emphasize on the fact that this is a revolution, both in ethics and laws, and we can also add in any sciences. At the very beginning, there was no law for the future because it was evident that the future would look after it himself. So from the very beginning, we have no need to think about the future nor future generations because the future was out of our power. So laws have been intuitively built, ignoring the future. Professor Alexander Keys has announced that for lawyers, introducing future generations into the law, into the field of law, was realizing a Copernican revolution. And to the point of view of Professor Mireille Delmas-Marty, professor of the Collège de France, she emphasizes on the fact that this includes an anthropological disruption for the Occidental civilization. So at the starting point, we have to be conscious that we have no benchmark to govern the future. We need even new words. We need new ethical and legal foundations in order to think about this future and to inhale this peace with the future. So I shall recall the words of Tony Oposa, who is the leader of the Normandy Chair for Peace. And we have chosen the picture of the earth. And he says that we will have peace on earth when we have peace with the earth. So this is the general matrix of the Normandy Chair for Peace. And I would like to emphasize on this picture because in 1972, when for the very first time the NASA took this picture of this small planet, this Earth, which was in this picture, in one picture, it generated spontaneously at the world level what we call now the overview effect for the astronauts, which means that when we see the Earth, spontaneously, we have this aim of protecting the Earth. We can imagine, we can figure out its vulnerability and also think about future generations. So I had exactly, and I'm sharing the analysis about the SDGs because to my point of view, the SDGs is also part of this new matrix for a renewed civilization contract, because this is not a social contract as Rousseau, the French philosopher, initiated, but a contract for the future of humankind and all living species and of the Earth ecosystem. So the SDGs can be an important matrix because, as you know, the very concept of future generations is part of this definition of sustainable development, and it has the power to disclose our way of thinking in law on issues which happens presently, but also in the long run. We have many concepts which are already included in international law, but also through different normativity systems, such as the one of common heritage of humankind, sustainable development. And we can imagine that these are the examples that there is an emergence of a law for the future. And my main work, in order to provide this approach of peace with the earth, of peace, sustainable peace, is based on a transgenerational analysis of human rights. So I will be brief on the philosophic part, but I used to teach to my students that we are at the core of a revolution, of a scientific revolution. And I like this quotation of Thomas Kuhn, who's emphasizing on the fact that scientific revolutions are mostly silent. More and more and more people are now engaged through this new paradigm, which is ecological paradigm. But still, we need new words, new ethics, as I say, new norms, new laws in order to protect the future. So there are many books that we can read about this question of taking care of the future, such as Hans Jonas, The Imperative of Responsibility, where he states that we need new ethical tools in order to protect the future generations, because now with the technological society, we have entered into a new era where we're putting into danger the future generations. And we cannot do that without any adaptation of the fields of our ethics. Günther Anders is more specialized on the nuclear threats. And to his point of view, the threats of the total destruction of humankind is just something so much violent, which is totally unacceptable. And other people use the word Anthropocene. The idea is always the same. Humankind has acquired an unprecedented power on the earth, on the very condition of the living and those to come. And this is urgently calling for the profound metamorphosis in ethics. So I will go further because I need to keep the time, but I have some major quotations to illustrate all of this. Günther Anders says that there is a disruption between what into the concept of history, because there is a gap, a tremendous gap between what we can do now, the power of human, and what can human thinks from a very ethical point of view, and we can say also legal point of view. And this changes the very foundation of our moral existence. He talks about Promethean gap between actions and abilities of our imagination. So we need also to strengthen the matrix of how do we think about the future. There is a new branch of philosophy, which is the disaster philosophy. And it helps because it provides an extension of the ethical concept of disaster. The very concept of disaster should be enriched and extending to the risk of disaster due to industrial activities, new technologies, nuclear technologies, pesticides, etc. And I like particularly to quote Jean-Pierre Dupuy, which emphasize on many paradoxes in the very concept of catastrophes, because we have to think about its possibility in order to mobilize our action. But what he says that for if one is to prevent a catastrophe, one needs to believe in its possibility before it occurs. If, on the other hand, one succeeds in preventing it, its non-realization maintains it in the realms of the impossible, and as a result, the prevention efforts will appear useless in retrospect. So we have to think about this reality. Anticipating transgenerational threats or damages means that we have to anticipate disasters, catastrophes, and to be conscious that if we do correctly the work, then it will appear afterwards, maybe to some people, regardless, inutile. So the Anthropocene era is now a word used which means that the humankind has acquired an unprecedented power on the earth, on the condition of the livings and those to come. We have many possibility to identify that, radionuclides around the world. For other people, it will be plastic pollution throughout the world, etc. So definitely, I think that we have entered into a new legal era, and the pioneers, we can quote them because we are a family, and the Moderator for Peace emphasize on the transgenerational approach. And I shall quote here our professor Edith Brunweiss, who wrote the very first book on justice for future generation, and who has formulated for the very first time intergenerational legal principle. And she has opened a new way of thinking. And one of the pioneers, who is the leader of the Moderator for Peace, is attorney Tony Oposa, who has won the very first case about deforestation in the Philippines. And he managed to stop this deforestation on behalf of the interests of future generations. Another way also to explain all this new approach of human rights and duties, I will explain more particularly the duties also, because it's an asymmetrical paradigm that we have to recognize, is to explain that we have to avoid the tragedy of human rights. This expression insists on the urgent necessity of giving respect for the future foundation in law. The first time I saw this expression was it was by Amnesty International concerning a report on the Niger Delta, but it can be also be used for nuclear disasters and any transgenerational pollutions or threats, pesticides, endocrine disruptors, nuclear pollutions, etc. So the idea is also to say to those who do not want to green human rights, who do not want to green the very concept of peace, is to say that, well, if you do not green human rights, or you refuse that, at the end, in the long run, it will be the tragedy of human rights, because the very concept of human rights will be downgraded into the obsolescence. There is tragedy of human rights whenever a return to the status quo is impossible, whenever conditions for life are adversely affected, the very concept of human rights makes no sense. This is true for all the what we call the ghost cities, such as around Fukushima, around Mayak, around Chernobyl. As humans, from our anthropological condition, we cannot stay in those areas because it will put us into danger. It is the same also for pesticides, which are endocrine disruptors. We know that it has transgenerational effects. We know that fetuses that are exposed to endocrine disruptors can have effects immediately and have what we say congenital damage, but all along their life, these endocrine disruptors to which they have been exposed when they were fetuses will have effects, can have adverse effects, such as puberté précoce, early puberty, I don't know the word in English, and many other problems. And all this new way of thinking about saying, if you do not change the paradigm, if you do not transgenerational human rights and integrate duties for our present generations towards future generations in a transitive logics, then if you do that change, you can apply that to every transgenerational threat, such as climate change. And this very paradigm, which is specific, has only vocation to be applied at the very specific time when the future is under threat, under major control of our actions. So anytime we put the future into danger, we have a duty to take into account the rights of those to come. The duty of diligence now has to be applied towards the future too. So rapidly, this is very the most conceptual part, and I want to be very concrete. But in my thesis, I plead for a change of paradigm, for a paradigm shift. I formulated two major legal foundation principles: the principle of temporal non-discrimination, which means that the non-existence of future generations can no longer be synonymous with an absence of legal protection, because we are now making a difference for future generations because they are not living now. But if we put them into danger, democracy cannot accept irreversibility, cannot allow transgenerational damage. So in other words, it's a kind of abuse of power by present generations over the future. And I'm not talking only about humans, about people, but also about the earth ecosystem, about other species. It's a transgenerational, transspatial, and transspecies approach. And the second legal principle is the principle of dignity of future generation, which permits to propose a transgenerational approach and lecture of future generation. I will explain that rapidly. So if you want to go further, this is the very first book that we have published within the Moderator for Peace collection, Legal Action for Future Generations. So you can go further on that topic. But I would like to explain to you, what do I mean by a transgenerational approach of human rights? Once you do the change of paradigm, and I'm teaching that since 6 years to my students, then it appears easily that the right to life is no more only the right not to be threatened by death penalty, but it can be also a transgenerational individual and collective right. It can become, for example, the right not to be born with chemicals in the body, like with endocrine disruptors. You know, we have more than 200 residues at least of chemicals. Each baby which is arriving on this earth is already polluted by pesticides and chemicals residues. We can say that the freedom to come and go in some areas is no more a reality. So we can have both analyses from an environmental point of view, from, like I said, on Fukushima and Chernobyl, but also with new technologies. In some countries, you are always under the light, under the cameras, and you cannot say that you have still freedom to free and go. So all my work is to propose to transgenerational human rights, such as the right to health. The right to health is also the right not to be exposed to chemicals, to radiation, which have transgenerational effects. We know that already now in Vietnam and other countries. And this is the very revolution, is that it calls for a metamorphosis of fundamental rights and duties. We have to recognize duties towards the future. And I will conclude that there is several generations of human rights. For instance, some people are calling for the recognition of a new fourth generation, which will be applicable in bioethics. The very question of the enhancements of humans by genetics, by technologies, by very different sciences is now at an actual topical question, topical issue. So there are also, I have just 1 minute to conclude, various declarations which propose that, from Commandant Cousteau at the University of Laguna in 1993, which led to a UNESCO Universal Declaration of Rights of Future Generations. We proposed a universal declaration with Corinne Lepage to the French president in 2015. But now we can see that in all regional human rights systems, there is now the recognition of human rights, and they make the link with future generations. Also, in countries such as in Colombia, there is a twin case of the Oposa case on deforestation. And last but not least, the very last decision of the German Federal Supreme Court recognized rights and duties towards future generations. So this is what I would like to conclude on, that there is a momentum of transformation in every legal system from the universal, regional to national levels, and it makes an alliance with the recognition of rights of nature. So we have also a new call for Ombudsman for Future Generations, and that has been approved in Marseille. Thank you very much for your attention, and I hope that I respected the time, dear Kathryn. That's all for me. Thank you very much.
I would just like to say that your rethinking of law, because of the scale and scope of the harms that humans are capable of, from nuclear war to poisoned soils, that has to occur. We need a new language, a new structure even, to consider future generations. And I know one of the questions actually in the Q&A raises Indigenous thought and thinking with future generations, which is core to that, of course. So thank you, all of our speakers. We will now turn, we have about 15 minutes, so we'll turn to some of the questions and answers that have come up. The first question actually came right before, Alyn, you had finished your presentation and started to unpack a little bit on the connections between nuclear weapons and climate change. But what do you think, and perhaps Amelie can also add to this, are the strongest lessons learned between the nuclear weapons conversation and climate change harm? So first, Alyn, could you respond? And then Amelie, if you have anything to add.
Yeah, thank you. So I'll address two aspects of this. The first one is the specific question which was put into the question answer, which is what about the impact of nuclear weapons on the climate? And then I'll do the broader question which you asked. Nuclear weapons, the ones that have been tested, that is, they've been detonated for the purpose of designing and developing new nuclear weapons, they haven't had much impact on the climate. Their impact has been the long-lasting radionuclides that have been released and physical destruction to the territories where they've been detonated. The huge force of the explosion, for example, is vaporized islands, and then put radioactive contamination, which is still around, whether it's the Marshall Islands, where it's in the middle of Australia, where it's Nevada, where it's in Kazakhstan, where the Soviets did the testing. But they didn't really have an impact on the climate. What, though, has been postulated, and now some of the same people, the same climate experts, so Alan Robot and Owen Toon, who were doing the climate modeling for climate change impact of carbon emissions, also then looked at what would happen if nuclear weapons are used in wartime, which is different than using during peacetime and testing. During wartime, you would be using the nuclear weapons on targets which have flammable material. You would be using multiple detonations at the same time. And what they did in their exploration determined that there would be huge firestorms, which would create huge amounts of soot that would go into the atmosphere, and that would have a very devastating impact on climate. So nuclear weapons used in armed conflict in wartime would have a devastating effect on the climate. The nuclear tests haven't had that impact on the climate. That's sort of the difference. The broader concept is, what are some of the other connections, though, between the climate issue and the nuclear weapons? And we've been exploring that with World Future Council and with PNND, and I've just put in the chat a link to some of the work we've been doing on this. We called it the Climate Nuclear Disarmament Nexus. And it looks at some of these key issues. Now, one of which is that both of these issues are ones that are dealing with impact on global environment, not just on a national level. Both require a shift from a nationalistic approach to policy to a more global approach on policy using common security and human security framework. What that is that's different to your traditional militaristic framework of security. The militaristic framework of security basically postulate that I'm secure if I can protect myself against an enemy by ensuring that I've got sufficient force, whether it's military force or other sort of force. It's a zero-sum game because you're actually creating more insecurity by threatening the other, and you're not resolving the conflicts that lead to the suspicions and adversaries anyway. A common security, human security framework is looking at resolving these conflicts. It's looking at working in cooperation with or trying to work out solutions with those who may think differently. You may have conflicts with the adversaries. You treat them not as those that you have to fight against, but those that you need to help resolve the conflict together. We have to do that for climate change. We can't just base it on one nation against another, because if one nation tries to do a wonderful job on addressing their emissions, put on environmental controls and things like that, they put themselves in an economic disadvantage to those countries that don't do it. So a competitive economic framework that we are currently having is very, very difficult to manage the climate change. And it's also very, very difficult to manage the nuclear weapons issue. So this is the important thing. We have to work on common security and human security to protect us, whether it's from nuclear weapons or from climate change.
And here you're talking to a bunch of lawyers or future lawyers about changing from an adversarial system to one that is cooperation based, and that would be the required change for that. Emily, did you have anything to add?
Very quickly, because the answer of Alyn was perfect. Just to say that I like to quote Professor Mireille Delmas-Marty, who says, she says that we have to change of paradigm from sovereign states to solidarity between states. And indeed, one of the change of paradigm is that we are out of the paradigm of state nations. Our sovereignty now is a common sovereignty, is a duty to protect the future. The UN has a duty of diligence in order to provide sustainable peace now. So we have to think a little bit out of the box, but we do not have any choice, actually. Hans Jonas, the philosopher, said, I know that when I'm talking about ethics for future generations, you are thinking that I'm trying to take the moon, but we have no choice. And this is a principle of reality. We have a choice of civilization to make, and together we have all the science. And just the balance between climate change and nuclear. You know, for nuclear fields, there have been a lot of things which are not very well known. We can talk about the do you say the jellyfish babies or jelly babies, Alyn, which is horrible. Actually, we put into danger our previous generation, but radionuclides have eternal pollution, such as mercury and all other things. And for climate change, is that it is rather, we think it's rather in the future, but this future is already ongoing. The difficulty is that for climate change, there is a time lapse between the actions and the effects, and the lawyers are not used to integrate this temporal distanciation in the fields of responsibility. So this is also something we have to think about.
Talk about cooperation, you talk about solidarity between states, but your temporal focus is solidarity between generations. I mean, the rights of future generations, I think, is the only legal concept where you're asking the people of now to limit themselves, have a duty to limit themselves and constrain themselves for the rights of futures. And it's like my mentor, and Emily, I love that you put in your presentations the people that inspire you, because we all need to do that. My mentor, Ron Engel, says it's what constrains us that sustains us. It's through our limitations and our relations that give us life. And it's true and foundational to all of this. I think I'll turn to the second question, which perhaps Juan Carlos could help us with. And how would you reconcile with the principle of reconciliation, also another Virmantri norm in a lot of his writings? How would you reconcile sustainable development with Earth carrying capacity?
Oh, thank you. I mean, I think it's on the core of the whole idea of sustainability is sustainability with an intergenerational responsibility, and this idea of intergenerational responsibility is on the core of the protection of the planet. I think is, you know, I mean, for me, it will be very, very difficult to separate, to divorce these two concepts. Even I think one of the important additions of the Agenda 2030 is to see sustainability not just from a very limited environmental approach. I think we need to see the whole concept of sustainability from the environmental perspective, but also from the human perspective and their interrelation between of the human being, their culture, and the environment. And I think when you read the Agenda 2030 with an open mind, and then you see the 17 different elements from the 16 that targets the core, plus the 17 that call for the coalitions of the people to work for it, is on the core of this idea of carrying the earth, carrying our mothership or the mother earth, depending of where are you in the cultural position under your relation with the earth. But for me, is consubstantial on the idea of sustainability. That would be my side. Yeah, thank you.
I think then we may have time for one, maybe two. Well, let's end with the question on Indigenous peoples, Indigenous laws, Indigenous beliefs. Do any of you work within that, or how we are incorporating Indigenous cultures, beliefs, peoples, and not necessarily putting their rights in our Western system, but it's also recognizing their own laws as legitimate laws. You know, it's what they do does not have to be placed into Western structure to be legitimate. So how is that working with the evolution of global environmental governance? Alyn, could you please answer? Thank you.
Sorry to take the floor again,
No,
but there
please.
was, because we are, of course, in Aotearoa, New Zealand, which is where one of the references came to from Māori, we are very much engaged with some of these principles that are in customary law from the Māori Indigenous communities. One of those in particular is Katy, which is the principle of guardianship. This is the principle that we are primarily guardians of our environmental resources. Resources is a strange way of putting it, because resources sort of assumes that it's something that's of value to human, but really in the Māori term, it's treasures, which is something which has got its inherent own right. And in fact, that's also come into some law, including in court cases. The Whanganui River, for example, has been granted the rights of like the same rights as a person under a court case in New Zealand. And the work that we're doing, and I think this is a segue to the next event you're running with the New Zealand Centre for Environmental Law. We're actually got a project, World Future Council, the New Zealand Centre for Environmental Law, and the Right Livelihood College, on getting some of these concepts and the idea of trusteeship, guardianship, and how these principles can be brought into mainstream law as well. Now, it's not that they're absent totally. There are, examples of that, but I think that the person who's asking the question is quite correct. There's a lot greater attention given to these aspects of protection of future generations, of ideas that we don't own the world, that we are part of the world, which is not just in Māori tradition. Chief Seattle from the United States, the glorious statement that he wrote about, we are part of the world, we don't own it, is one I think is well known in the United States. There are many, many examples, from Indigenous traditions. So it is something definitely which people are now sort of, trying to bring into mainstream, and not just leave it as like two separate legal systems, but like how we can bring it into the development of law, environmental law, and other branches of law.
Great, thank you so much. Does anyone else have any direct work with Indigenous communities or their impacts in your own work? Emily, please.
Yes, actually, I have also, within the NCP, we have a line dedicated to indigenous people. So we went in Colombia, we met the Kogis, and we definitely think that we have to enrich our legal matrix. And other people have words such as decolonization of norms. They use this expression. And I think that the idea is to make a great alliance of our different way of thinking and to respect the legal pluralism and also legal different variety. So this is what makes our history and our contract of civilization very rich, because it is plural. I don't need, an Occidental do not need to impose its way of thinking, and there is a reciprocity by that. And if you think about rights of nature, of indigenous people, and rights of future generation, whatever is the entry, the goal is the same. So there is also other hypotheses of Gaia's theories, whatever. But I would say that the nominated chair for peace is also supporting this idea. One of our projects, and you know, SDG 17 is to create partnership for the goals. So you're all welcome. It's an inclusive academic chair. The idea is also to question the very concept of right of access to nature, from indigenous people lenses to non-indigenous people lenses. And for instance, for French people, just a small illustration. We cannot go, we are not free to come and go during the weekend or during the week because there are hunters and we have a lot of accidents. And here we are calling for the recognition of rights to access to nature. It would be normal to have access to nature with our kids and go to the forest, because people get killed. But for indigenous people, you have other links, more complex, with some plants, which are necessary for their cosmogony and for the respect of the nature. And I think that this highlight can be interesting to say, what is the right to access to nature, and to show it in every cultural point of view. So if you're interested, you're all warmly welcome.
And I think ending it in the spirit of cooperation and an invitation to cooperate is the perfect way. I thank you, each of you, so much for being here. I thank our panelists, our participants, all of the organizations and heart that you represent. I look forward to a future together. If anyone has any questions for follow-up, please email elga@elgaworld.org. And I hope to see you all next month in all future work. Thank you so much to each of you. Thank you.
Bye-bye. Take care.
Bye. Bye-bye.